Welcome, everyone. I am so pleased to see all of you this evening. We have a wonderful gathering, and I want to acknowledge some groups in the room tonight, including Ken Bamberger's Jewish Law class, our Institute's undergraduate fellows, alumni fellows, and parents of our fellows, Berkeley faculty and faculty from other universities, Robbins collection staff, and many members of the community. Just 1 month ago, our institute shared the news that the Helen Diller Foundation awarded a $10 million endowment gift to name the Helen Diller Institute for Jewish Law and Israel Studies, formerly Berkeley Institute for Jewish Law and Israel Studies. We are incredibly grateful to the Helen Diller Foundation for their generosity in making this moment possible. Their gift ensures a lasting legacy for the Institute and its important programs on the UC Berkeley campus, including its program on Israel Studies, its program on Jewish law, thought, and identity, its undergraduate fellows program, and its visiting faculty and scholars program. The announcement of our new name also kicked off a year of celebration, marking the 10-year anniversary of the Institute's founding. You are joining us today for the third program we are hosting under our new name, and believe me, the novelty has not worn off. Even harder to believe, the distinguished annual Robbins Collection Lecture in Jewish Law, Thought, and Identity predates our 10-year anniversary. Born of a partnership between the faculty directors of the Helen Diller Institute and the Robbins Collection and Research Center in Berkeley Law, directed by Professor Laurent Mayse, today's lecture marks the 12th year of this special collaboration. Previous distinguished speakers have included Michael Walzer, Suzanne Stone, Moshe Halbertal, Susanna Heschel, and many others. The Robbins Collection has been instrumental in the Helen Diller Institute's success these past 10 years and has been an incredible source of support and inspiration. As an institute nurturing a program in Jewish law, thought, and identity, it is awesome to share space with a rich collection of religious law manuscripts, including those of Jewish philosophers and legal thinkers. I am grateful to all our partners at the Robbins Collection, Laurent Mayse, Emily Best, Jenny Nelson, Jesse Sherwood, Ryan Furtkamp, and all their staff. Before I introduce our speakers for this evening, a few housekeeping issues I want to address. Our speakers will have the floor to present Jewish law for the digital age. We will mute all attendees. When we turn to Q&A, we will call on students to ask the first questions, and then we will look for other electronic hands raised in the audience. Please note that students will always have priority for questions. Now to introduce our speakers. Kenneth Bamberger is the Rosalind and Arthur Gilbert Foundation Professor of Law at UC Berkeley. He is also faculty co-director at the Berkeley Center for Law and Technology and the Helen Diller Institute for Jewish Law and Israel Studies, which he founded. Ariel Evan Mayse is Assistant Professor of Religious Studies at Stanford University. He is a Senior Fellow at the Berkeley Program on Jewish Law, Thought, and Identity, and Rabbi in Residence at ATIC, Jewish Maker Institute. Please join me in welcoming them to talk about Jewish law for the digital age.
Thanks so much, Rebecca, and thank you all for being here tonight to hear about our work. In December 2018, the New York Times bought a widely available commercial data set containing location information collected from the apps that we all have on our phones that offer us things like weather reports and the location of nearby restaurants and stores. The data set, one of many of its kind, contained location data from hundreds of millions of individuals, each updated hundreds or even thousands of times a day. The individual pieces of data in these sets are formally anonymous. No names are attached, but because the data is recorded by individual phones, it tracks your every move. From this data, the New York Times was able to identify a 46-year-old math teacher named Lisa McGrin. She was the only person who made the daily commute from her home in upstate New York the location of which is publicly available, to the middle school where she works, also publicly available, 14 miles away. And once you've identified someone that way, you can learn a lot more about them. The Times followed Lisa's data trail to Weight Watchers, to a dermatologist's office. They knew she visited her ex-boyfriend's home. None of this was illegal. The data set was widely commercially available, and each individual piece of information was purportedly obtained with her consent, given when she installed the app or configured the privacy settings. She was, not surprisingly, wigged out by this. It's the thought of people finding out those intimate details, she said, that you don't want people to know. Others are more sanguine about this technical capacity for surveillance and the implications for privacy. Privacy, said one of the two fathers of the internet, Vint Cerf, to the Federal Trade Commission a few years ago, is an artifact of a modern age nearing its end. It was, he described, an accident of the urban revolution, an anomaly created by certain technological and architectural moments, namely the Industrial Revolution and the growth of urban concentrations that led to a sense of anonymity. Indeed, according to Cerf, privacy didn't exist in the small towns like the one he grew up in which everybody knows what everybody is doing. And in the big data age's small town analog, he said privacy will be increasingly difficult for us to achieve going forward. Now, to be sure, Cerf has, as a descriptive matter, identified an important turning point in privacy. Technological capacity to circumvent the physical architectures of anonymity has enabled pervasive public and private surveillance of everyday life. The discourse of privacy that arose in the shadow of these protected architectures, rooted in Warren and Brandeis's notion of the individual right to be left alone, or the European commitment to informational self-determination, offer weak sauce against rampant data collection and aggregation. The legal regimes this language of individualism inform broadly replace the substantive promise of privacy as a fundamental human right with illusory procedural safeguards of notice and consent, manipulable protections by which individuals agree to privacy terms, often with little understanding of the terms of the bargain or awareness of future uses of information about them, or power to negotiate or opt out. Jurisprudence struggles to comprehend the effects of intrusive surveillance and information collection as the task of shoehorning individual injury into existing doctrine leads to cramped understanding of the real harms of surveillance. The rubric of individual rights and individual control over one's personal information, moreover, often undermines privacy by misdirection from the reality that our individual lives and individual privacy are enmeshed with broader society. It obscures ways that in the new small town of the big data age, privacy rights are deemed waived or never even coalesce as a condition for participation, both online and real life. And through a technological determinism rooted in a language of expectations of privacy, if a human or a digital eye can see you, or scrape records about you, or use the resulting knowledge to make inferences about you, privacy interests are often deemed not to exist at all. Finally, framing privacy as an individual interest often ignores the interconnected nature of human behavior and of human interests. Surveillance of any one individual can reveal a great deal about others, slicing away at their privacy without any pretense of consent in the waiver of their rights and interests. So, This modern discourse of individualism ultimately masks a postmodern technological capacity that permits near ubiquitous surveillance of our behaviors, of our interactions, of our locations, and our personal spaces. It conceals the ways that this capacity could be manipulated by entities whose financial incentives demand ever-growing digital dossiers on individuals using powerful computing in service of increasingly strong ways to monetize our every behavior. It fails to provide a language to sufficiently capture the harm that pervasive surveillance wreaks on individuals and social relations, or to offer a counter vision for the technological power of this big data age. Yet if Cerf's comments resonate with the failures of the dominant modern articulations of privacy, his associations of privacy with unique technologies of modernity also fail. Specifically, his claim is undermined by a robust millennia-old and self-evidently pre-modern Jewish legal tradition, which has long articulated a vision for the protection of privacy by mandating both preventive architectures and appropriate behaviors regarding visual and oral surveillance, the protection of communications, and information collection, sharing, and use, often in tightly knit and transparent communities like those of Cerf's youth. Jewish legal sources present a vision that roots the importance of privacy not only in the protection of the individual, but in the set of values prerequisite for a vibrant and flourishing and functioning and good society. Through both narratives and doctrine, Jewish sources animate what's at stake in the protection of privacy and the ways that privacy harms can rend the fabric of society, with severe implications for its members. As a consequence, the Jewish vision departs radically from the usual building blocks of current privacy discourse. It locates neither the meaning of privacy nor the mechanism for its legal vindication in individual rights. Rather, reflecting Jewish law's principal character as a system of ex ante obligations, it establishes a set of prior commitments that help us answer the question of what behaviors are appropriate, rejecting both technological determinism and the related notion of expectations as delineators of privacy's content. Privacy rules depend neither on the confidentiality or secrecy of the information. Anonymity is not a determinant of privacy. In fact, in Jewish law, rules of behavior presume its absence and apply even when it exists. You don't have to show concrete or personal harm. And Jewish sources often reject consent as a basis for intrusion, and privacy protective behavioral mandates on both the surveilled and the surveyor may remain binding even if both sides accept the situation. Finally, even when certain types of personally sensitive information or knowledge are publicly known or can't help but be visible, Jewish law provides rules against their use or their sharing. Together, these doctrinal elements combine to offer a framework for privacy protection and a language about privacy's meaning, with promise for combating big data abuses, a language that's missing in current discourse. Maimonides, the Rambam, offers a construction of the biblical commandment, lo telech rechil, don't be a talebearer, which on its face deals with information sharing, that is exemplary of this legal tradition. The Rambam understands the totality of the dangers of the interlinked elements of surveillance, including not just sharing, but the collection and use of non-secret information about others' actions, familial details, and other knowledge. The Rambam says one who loads himself up And he uses the word to'ain, the word for what you do with a donkey, piling things on top of them. One who loads himself up with words, truthful words, and goes from place to place and says, thus said so-and-so, and such I have heard from so-and-so. Even though it is true, this destroys the world. And regarding this, scripture says, may Hashem cut off flattering lips, the tongue that speaks proud things. So what can this Jewish language bring? As we'll sketch out, it suggests a move from individual control over information as the mechanism for shaping privacy's meaning and its enforcement to a regime of substantive obligations on all societal members, personal and organizational, to protect privacy. It recognizes the interconnected nature of human interests and comprehends the totality of the harm that pervasive surveillance wreaks on both individuals and society. It offers a conceptual basis for extending traditional privacy protections to online spaces and to new data uses. And it provides a language of dignity that recognizes unequal bargaining power, rejects the aggregation and use of information to create narratives and produce judgments that confine personal growth and free choice, and it demands equal protection for all humans. Ariel?
Wonderful. So we've heard from Professor Bamberger that Warren and Brandeis mine common law doctrine to weave together a coherent modern legal vision of privacy protection. This is framed as an actionable right of the individual to be left alone, and it's placed in that individual's power to determine, as Thomas Cooley argues, the extent to which his or her written work, thoughts, sentiments, or likeness may be given out to the public. This right is, in some sense, the core armature to which all American privacy law adheres. Scholars, courts, and policymakers debate the contours of this framing, as well as the interests a privacy right should protect and the harms that it should ideally prevent. But the shortcomings of this approach have been well documented as well, especially as greater technological rupture of the digital age overtakes us, and in the veritable digital civilization in which we now find ourselves, indeed, at this very moment. We see these failings emerge from scholarship, in recognition of regulation and its discontents, but also in our own lives. How can Judaism contribute to this discussion? Does Jewish law have anything relevant to say? Well, I know where to find the Jewish laws of the Sabbath, of prayer, of marriage, and of funerals. I even know where to find Jewish civil law and torts on restitutions for goring oxen, contracts, mergers, and acquisitions. But there's no subsection of any classical code of Jewish law that I'm familiar with called Hilchos Privacy or privacy law. So maybe it doesn't exist. Mark Wachowski, a noted Jewish legal scholar, explains that reading Jewish law through the modern lens of privacy requires a similar kind of legal reverse engineering, much like that taken by Warren and Brandeis. This groundwork and legal archaeology was further achieved in the exhaustive treatments by the eminent Israeli scholar Nachum Rackover and his colleagues. His monumental work brings together a diverse range of doctrinal sources dealing with the prevention of visual and spatial intrusions, as well as information collection, use, and sharing, to argue that what we now understand as privacy is an essential value in the Jewish tradition. So, in a sense, it was there the whole time, just waiting to be discovered. You had to brush the sources in the right way, but it was waiting to be found. Doctrines at the core of this include hezek re'iyah, harm from seeing, as well as prohibitions on hezek shmi'ah, a kind of tortious or impermissible auditory surveillance. These categories are, in a certain sense, the closest thing in the Talmudic world to our own modern issues, and they generate a bunch of paradigmatic mandates regarding building windows, walls, how to share courtyards, and these sorts of things. A second core doctrine is the Takana, or enactment of Rabbeinu Gershom, who lived in the end of the 10th and the 11th centuries, a famed medieval ruling that has murky origins, but had a significant impact on Jewish law and culture, because, among other things, it spells out a prohibition against the opening the mail of another individual. Although perhaps initially enacted for the purpose of preserving trade secrets, the Takana, as applied, subsequently prohibits harvesting information from all kinds of personal communications, whether or not it is carried forward further. These core doctrines outlined by Rackover also include a variety of speech rules about what truthful information or knowledge about others, whether it is publicly accessible or not, and again, even if it is true, can or cannot be shared. These include the biblical prohibitions that Professor Bamberger just mentioned against tale-bearing, which has implications both for the collection of sensitive information as well as the sharing of it with others. This category also includes information that might be compromising, that might feel uncomfortable, that might have to do with sensitive issues of someone's history, their family status, their religious status, or the history of their own religious observance. Such topics, even when they are known by some, indeed public knowledge, are barred as a part of public or revealed discourse. Now, Rackover's vast work, which is indeed incredible, provides a remarkable resource for categorical redefinition, but it does not bring the range of Jewish law doctrines together into a kind of united landscape. And so our project seeks to take this foundational work many steps further. We look to draw upon the full range of Jewish legal discourses, reading these discussions in their broader narrative, ethical, and doctrinal contexts to develop a conceptual framework. The result, we hope, will be of relevance not just for current Jewish legal interpretation, but also for broader discourses about privacy in the face of widespread surveillance and the technologies that enable it. We seek to make Jewish law part of today's legal discourse while also contributing to the formulation of Jewish law that is relevant for today. Now, we are hardly seeking to enact legislation from antique or medieval sources that emerged in a very different time and a very different place. And as is well known, Jewish law is in some sense a conversation that spans the generation, a discourse that is spurred on by specific questions and particular cases which are embedded in time and place. But Jewish law is also driven by a kind of jurisprudential dialogue across time and across geography, spanning from ancient Palestine to every place that Jews have lived, including Berkeley. So the goal is to think with these sources of Jewish law, allowing this thick tradition to enrich our modern thinking, as well as to challenge our mindsets that have neither the values nor the vocabulary to deal with this complicated and thorny problem. We emphasize that the derivation of jurisprudential lessons and modes of reconsidering competing values from Jewish law is what we are after, not this wholesale or simplistic attempt to transplant substantive doctrines into American law. So rather than an act of passive archaeology, the project is one of active construction, but one that moves beyond the hunt for ready analogs to Western Jewish jurisprudence. By way of comparison, we could undertake a similar project regarding Jewish law and its relevance to contemporary environmental law and ethics. Rather than seeking to think about how do we say stewardship or ecology in Jewish, or seeking how to find easy correlates to the Safe Drinking Water Act or the Toxic Substances Control Act, the voice of Jewish law goes deeper yet, offering a powerful rebuke to the values of carbon capitalism and to the instrumental reason and to the unfettered extractive vision of the natural world that has led us to this breaking point. So too in our case. The animating principles reflecting the scope and implementation of Jewish law reveal a very different understanding of privacy's goals, the harms to be avoided, the methods for its protection, as well as the different visions of privacy's role in society and of the individuals within it. translating Jewish jurisprudence into contemporary contexts involves drawing new paradigms from legal sources. It is an act of selection, and we recognize and affirm that not all jurisprudential strands can or should be highlighted or brought into this dialogue. Now, reading the Jewish tradition with care and attention to these potential pitfalls will permit us to draw upon its concepts and its vocabulary in order to mount a powerful challenge and an alternative to paradigmatic hegemony. In the words of Lin-Manuel Miranda, if there's a fire you're trying to douse, you can't put it out from inside the house. The fact that much of Jewish law predates our current situation of sweeping, systematic surveillance affords us a window into a different matrix of values and motivations. The Jewish legal tradition antecedes the conceptual restraints of liberalism and thus predates certain conceptions of the individual which undergird much of modern privacy mindset. As Robert Cover has described, and here I quote, "To be one who acts out of obligation is the closest thing there is to a Jewish definition of completion as a person within the community," end quote. Jewish privacy law's language of obligations, rather than individual rights, seeks to establish a social system that protects the dignity of each individual and places the burden on the community and all of its members for that protection. And yet at the same time, Jewish jurisprudence embodies a deep commitment to the protection of individuals and to individual choice as well as communitarian impulses. So by turning to Jewish law, we seek not to supplant liberalism, but to present the ethos of these sources as an ethical framework that can work within liberalism, enriching our discourse through challenge and critique. The quest is to reconsider the place of the individual within society, with privacy as a co-constructive value and a mutual obligation, returning certain dimensions of this project of modernity to its very roots. In that light, and acknowledging the anachronistic aspects of any attempt to present a well-hewn Jewish doctrine of privacy as emerged from these rabbinic sources, we now seek to identify 5 pillars or 5 lessons of Jewish law along axes that will nevertheless be familiar to contemporary scholars and practitioners of privacy.
Thanks, Professor Mayse. What I want to do now is share some of our work in that archaeological construction and give a sense of what these 5 pillars of Jewish privacy are that can instruct us in our own American discourse. Specifically, our work draws from a range of Jewish privacy doctrines to flesh out the importance of 5 things. First, Jewish privacy's framework. Second, its understanding of privacy's harms. Third, the ways that privacy's meaning is determined. Fourth, Jewish privacy's view of the individual. And it also struggles with, fifth, the negative implications of privacy. Each of these pillars reflect an important contrast with current American and Western approaches to privacy. So pillar 1, privacy's framework. Jewish law views privacy as an element of a good society and protects it through reciprocal duties rather than individual rights. If Warren and Brandeis's likely apocryphal privacy origin story revolves around the individual right to protect against intrusions, in their case, it was to exclude a paparazzi photographer from Warren's daughter's wedding, the Jewish origin story rings in a very different register. The book of Numbers tells the story of Balaam, a seer employed by the king of Moab who, though their enemy, ended up delivering a divinely inspired blessing on the Israelites after he lifted up his eyes and saw Israel dwelling tribe by tribe. What did Balaam see that inspired this blessing, asks the Talmud. He saw that the entrances of their tents were not aligned with each other. You couldn't see from one window or one door into another. And he said, These people are worthy of having the divine presence rest upon them. This notion of privacy as the way you construct society is built into the rest of the Jewish legal tradition. The laws of Hezek Re'eyah that Professor Mayse talked a little about are not included where you think they should be in the Talmudic tractate of Bava Kama, the subset of the of Nezikin that describes most forms of damage, like torts or criminal damage, and the various kinds of compensation owed for them. Rather, they appear in another tractate, Bava Batra, which largely deals with zoning laws. So, in the words of scholar Ariel Schreiber, in its Talmudic form, Hezek Re'eyah constitutes rules required for a peaceful coexistence between neighbors and part of a system of laws enabling civilized urban living. The Rambam, whose work, the Mishnah Torah, provided the first full Talmudic codification of Jewish law, includes this set of laws, the laws of visual damage, not in the book of his corpus he entitled Nezikin, damages, but that of Kinyan, which contains the laws that govern the rules of contracts and relations, and specifically in the section on Hilchot Shchenim, the laws of living as neighbors. And I hope you noted when you came out of the waiting room, a copy of the first page of Hilchot Shchenim from a 15th century Yemenite copy of the Rambam from our very own Robbins collection here at Berkeley Law. Rabbi Chaim Palagi, jurist and communal leader in Smyrna, offered two justifications for these prohibitions in his She'ilot Utshuvot Hakikei Lev. He said these rules of visual harm and avoiding visual harm and surveillance derive from love your neighbor as yourself. That which is repugnant to you, do not do unto others. Surveillance is repugnant and distasteful. Rather than love and care, it represents a kind of extractive relationship that alienates the other and treats every dimension of her life as a commodity to be sold and traded. More pervasive in the sources is the emphasis on modeling one's behavior on the divine characteristic of tzniut, humility, quietness, concealment, lack of ostentatiousness, the modern word for privacy. And the Malbim, an early modern legal theorist, describes this verse as Shoresh mitzvot shebein adam lamakom, the root of all commandments between the individual and God. So this vision of privacy as a godly way to structure society, the way to construct a good society, is implemented, as Rabbi Mayse said, in a reflection of that through multilateral obligations on all citizens to preserve privacy, both the surveyors and the surveilled, as a means to protect all members of society. So pillar number 2, privacy's wrongs. Jewish law understands and links the inherent harms of visual intrusion and eavesdropping and information and dissemination, all of it together. To be sure, US law comprehends the core dignitary harms of embarrassment or shame or emotional distress that animated Warren and Brandeis's concerns. But by and large, it's really failed to have a language that grasps the totality of modern day surveillance. Its discussions are fragmented into discussions of how should we limit information collection? How should we limit aggregation and use? How should we limit sharing? Fragmented between theories about the home and the community, about public spaces and private spaces. It doesn't have a language to talk about the dehumanizing effects of the sweeping aggregation of personal information into databases, the way that pervasive surveillance changes the human experience and limits human choice by turning the privacy subject into an object, and the ways that such aggregation can lead to characterization of individuals in a way that increases the power that others have over them. And perhaps most significantly, because privacy injuries often differ from those that are traditionally cognizable under the law, contemporary legal protection has been particularly cramped by requirements that even when a regulatory norm has been violated, those wronged fall into certain categories. You have to be a consumer, you have to have a financial relationship, or you have to show specific types of concrete or cognizable familiar individual harm. Jewish privacy operates differently in two ways. First, Jewish law is much more capacious in its comprehension of the ways that privacy invasions harm both individuals and social relations. Jewish legal sources and the narratives that animate them capture the devastating effects of intertwined activities of surveillance, of collection, of use, of dissemination, and the resulting failure to protect the tzniut of each person. So Nachmanides comes up with two reasons, two justifications for the laws of Hezek Re'eyah, limiting visual intrusions. He suggests that there is an inherent harm in illicit looking, something that we can't even comprehend in the Western tongue. He explains that the damage from seeing implicates the evil eye, the ayin hara, the denigration of the ideal of tzniuta. But he also says, like the Maimonides that we quoted at the beginning, that illicit looking leads to wicked speech, lishna bisha, pointing to the logical conclusion of seeing, the harmful sharing and use of the information and knowledge collected. So that's one way that Jewish law understands harms from which we can learn. The second way is that it doesn't require specific injury. There are categorical rules as a doctrinal matter, preventing privacy harms. It's considered a violation of those rules to be per se harmful. And so the operation of its prohibitions doesn't depend on any additional showing that the failure to abide by them would cause specific or demonstrable harm in the individual case. And in this case, Jewish privacy law operates similarly to the common law tort of physical trespass, which is considered harmful even when no actual damages ensue. Jewish law considers these privacy intrusions as isura, per se forbidden. There's no de minimis exception. Even a short glance is forbidden. And we can see this notion in one of the texts we discuss, a text from the Chidah, the 18th century Rabbi Chaim David Azulai, who underscores the fact that Hezek Re'eyah is not bound by the usual limits of Torah doctrine, including a required showing of damages. He examines a case where two parties build buildings with doors and windows facing each other all at the same time. They build them at the same time. Now, in that case, the privacy harm, which falls on both parties, wouldn't be legally actionable under tort law, because both parties would have equal claims and equal liabilities. No one's more wrong, no one's more right, no one has a greater legal claim. But he notes this arrangement is still strictly prohibited by the laws of Hezek Re'eyah. At heart, the idea of Hezek Re'eyah is not about actionable tort to remedy individual cognizable harm. The usual mindsets about individual injury don't guide what's going on. It's about sanctity. It's about building community. It's about moving away from licentiousness. It's about an invitation to a dwelling place for God. Pillar 3, privacy's meaning. Jewish law rejects expectations and technological determinism as metrics of what should be protected. Vint Cerf says we don't have privacy anymore because technology can get around all of these barriers. But Jewish law rejects a notion of privacy as determined by technological capacity. Instead, it embraces rules that reflect a set of prior commitments in the face of architectural choices and requires architectural rules for preserving privacy. So a millennium and a half before Larry Lessig highlighted the capacity of architecture, both physical and digital, to regulate, Jewish law doctrine embraced design as a purposeful tool for privacy protection. Yet Jewish law goes further. It also rejects a technological determinism that says, well, if you try architecture and you can still see around it and you can still collect others' information, it's okay. It says no. We are imposing affirmative duties of behavior on both the watchers and the watched to make sure that privacy is protected even when architecture is not sufficient to do so. Pillar 4, the concept of the individual. Jewish law posits the inherent dignity of every individual, recognizes that surveillance may constrain free choice by modifying individual behavior, and it creates space for individual transformation. In our work, we go through a multitude of doctrines and put them together in service of this understanding of the individual. But let me mention two. First is the notion of limiting waiver and consent, the doctrine of mechila, waiver, forgiveness. Jewish law constrains the extent to which individuals can waive strong privacy protections that we've just described above. Rabbi Yosef Karo, citing the Rashba and Nachmanides, says, even if the injuring party forgives and says, I'll suffer, we say to the owner of the window, it's forbidden for you to do this, since every moment you gaze on him and damage him with your sight, you transgress, and you cannot always guard yourself from looking at him. Rabbi Shneur Zalman says, it's forbidden to build these windows one against another, even if both of the two parties are happy, because it violates the quality of tzniut. You cannot waive your own personal privacy. You cannot consent to another to observe your deeds throughout the entire day. Why? Jewish law looks at ways in which that kind of surveillance limits your choices, changes your behavior. Being watched also creates narratives about you. And we can see that most in the doctrines about tshuva, about personal repentance, personal growth. In service of this ideal, Jewish law prohibits the repetition of facts, even when they're publicly and privately known. Facts about familial origins, past behavior. When someone's convicted of a crime and received the appropriate punishment, that person is, in a sense, exonerated of the burden of that action and doesn't carry with her an extended criminal record that will limit her future. And although these identities and these points of information might be well known to others in the community, they're public, which means under American law, there's no claim to privacy. But under Jewish law, simply mentioning these personal facts is understood to be harmful and prohibited. Pillar 5, struggling with the limits of privacy. Recognizing that privacy doctrines can create harms and struggling with how to negotiate their limits. So this emphasis on privacy and dignity and personal humility is complemented by a countervailing voice and value in the Jewish tradition. First, an important line of Jewish jurisprudence rules that certain kinds of sensitive information may not remain secret if it relates to potential harms. Privacy can be outweighed to prevent other harms. And second, modern Jewish discourse especially also recognizes that privacy and anonymity can be used as tools of oppression. The impulse towards tzniut, the word for privacy, or tzniut, the word for modesty, can be used to repress the voices of marginalized members of society, or to sweep things under the rug that can and should be brought to light. Struggling with the complexity of privacy is part of the work of creating a good society. When one embraces strong privacy, one needs to admit and account for harms. I've laid out these, in brief form, these 5 pillars. How can they help us? Where may they guide us and point us in our current privacy debate? I'll turn things back over to Professor Mayse.
The modern approach to privacy has failed to meet the demands of a big data age. Framing the issue as a battle between society or companies and the individual has largely emptied our public lexicon of a language either to conceive of societal commitments to privacy or to call out infringements by members of society against one another. Individual privacy is balanced against important social values, and it often loses out entirely. Large swaths of what is dear to individuals is deemed not protected because it can be tracked down in public, because it's not secret, or because it's not reasonable to expect it to remain private in the face of intrusive technological capacity. Massive collection, revelation, or use of information is often not prohibited because individuals are deemed to have consented to it as a condition in participating in ordinary life functions, or because privacy intrusions do not satisfy particular notions of cognizable harm or injury. Just think for a moment about all the waivers that you've signed to consent to new applications or to new programs in just the last week. The Jewish law doctrines discussed thus far and articulated so nicely by Professor Bamberger offer different languages and frameworks to address this constellation of failures. We explore contributions that they might make to privacy discourse and suggest 4 key points. Number 1, Jewish law helps us shift the focus from framing privacy as a negative right, as a kind of shield against intrusion, and toward articulating the ways in which it positively constructs and enhances communal value. Individual privacy thus becomes a social commitment, the responsibility of every member of society, personal and organizational. Moving part of the burden for privacy's protection from the individual across other members of society alleviates the anxiety and confusion surrounding the privacy paradox when people express a deep concern for the issue of privacy, but are practically prevented from protecting it because of the reality of participation in society, which leaves them open to nearly unfettered surveillance. The Jewish tradition, to be sure, embraces an end goal of promoting individual capacity to enjoy a private life. But by casting tzniut as a societal value, it shifts and distributes a large portion of the responsibility for enabling privacy across all societal members. Priscilla Regan has highlighted the costs of policy emphasis on, and I quote, achieving the goal of protecting the privacy of individuals rather than curtailing the surveillance activities of others. She has also suggested that by focusing on simple bifurcations between individual and society, privacy theory has struggled to find language reflecting the effects of the collective collection of information on the relationships between different members in society, whether private persons and private organizations, and the appropriate roles of each. Jewish law offers a language for understanding the reality that privacy interests and privacy harms implicate multiple parties. They are not discrete and unique to the individual. Framing privacy as a fundamental and a collaborative social value to be promoted through societal rules and prohibitions suggests mechanisms for legal reform that both remedy the collective actions created by the mechanism for privacy's vindication in the dispersed hands of the individuals. Number 2, Jewish law offers an important language for appreciating the totality, the severity of harms wrought by pervasive surveillance and data analytics, including spatial and emotional as well as informational damages. And Jewish law embraces a unified attention to the range of surveillance capacities, appreciating the interlocking danger of spatial intrusion, information collection, use and dissemination of that information, as well as visibility, exposure, and protecting privacy even when the individual is in public or the information is in public. Dan Solove has termed the secrecy paradigm, in which privacy is tantamount to complete secrecy, and a privacy violation occurs when concealed data is revealed to others. But if it hasn't been previously hidden, or if the surveillance occurs in a public place, then there is no issue. Judaism offers a different vision. By contrast, it rejects these sharp delineations and appreciates the inseparability of data and person, of space and information, and the totality of vulnerability that the individual faces across these multiple planes. Ruth Gavison has argued that, and I quote, "One can lose privacy merely by becoming the object of attention, even if no new information becomes known, and whether the attention is conscious and purposeful or inadvertent." End quote. The prohibition against repeating non-secret facts about another's history seeks to free these individuals from the constraints of historical or partial narratives about them. The harms of these outcomes, Jewish law and narrative recognize, is a dehumanizing and objectifying process. Judaism and Jewish law believe in the infinite capacity of a human being to change and to become. This offers a means for arguing that even if intrusive activities can take place as a technological matter, they should not. It provides a mindset to allow privacy protections to expand from traditional contexts to online spaces and new data uses. Number 3, Jewish law suggests that policy debates over national and state privacy legislation should focus on the adoption of categorical rules and prohibitions, both architectural and behavioral, as the legal mechanisms for substantive privacy protection, not just individual subject exercise of their privacy rights, which can be easily overtaken by technological advances. We must recognize that reasonable expectations face the danger of collapsing into technological determinism as scientific advances alter understandings of what is possible and therefore anticipated. Jewish law's embrace of categorical substantive obligations regarding what types of intrusions and which kinds of information collection, sharing, and use are impermissible on the part of the surveillors, as well as limits on the knowledge-revealing behavior of the surveilled, offers a model for far stronger privacy protection. And 4, Jewish law presents a commitment to each individual, or better, to the individual in society. Jewish law offers a distinct language for envisioning the privacy subject, one that focuses on the fundamental protections accorded them and the values those protections reflect, rather than an illusory promise of informational control in the face of overpowering technological capacity to surveil, to aggregate data, and to manipulate our behavior accordingly. Rather than largely ineffective notions about the collection use of one's information and fictive forms of consent, Jewish law takes seriously the power imbalances that can plague such agreements, prohibiting the waiver of many privacy protections and requiring explicit consent to do so in others. And Jewish law sees that surveillance can cause modifications of an individual's behavior, one that is inappropriate in light of Jewish sources and their commitment to free choice. Jewish law underscores the equal importance of effective privacy protection to each human. And in this sense, Judaism's regime of obligation may best reflect the aspiration of a fundamental human right to which the human being is inherently entitled simply because she or he is a human being. To stitch this up, we argue that Jewish privacy provides a vision of the individual, an understanding of their place in society, an appreciation of the privacy harms that they face, and a framework for their protection, one that can speak realistically to the dangers of big data capacity and can lead to stronger and more equally applied vindication of privacy interests. American law obviously moves the needle forward through democratic process rather than Judaism's common law jurisprudence and often ad hoc rulings that are rooted in biblical and Talmudic principles. But Jewish law's vision of what we're calling privacy in society adds an important and missing language, a different framework for appreciating privacy harms and considering privacy's purpose, and giving it new tools for its protection. Bringing this language into the policy discourse has the promise to both move privacy towards a set of prior legal commitments around which architectures and behaviors may be ordered, and to inform regulatory frameworks that guard personal privacy, but which are rooted in the reciprocal obligations and the relationships between society and the individual. Thank you.
Great. Thank you. Thank you both so much. I want to turn to questions, and I know we have some questions from our undergraduate fellows to start us off. So I'm hoping that Daniela Rosen, that you can start us with a question.
Sure. Well, thank you first, professors, for speaking with us. I wanted to ask how in America you would implement internet and cyber data security, as you were talking about, as a social obligation or as a societal value. I think as you mentioned, there are firms and institutions in America that benefit financially from, I believe you put it as monetizing our online habits and our online behaviors. And you spoke about translating Jewish law, but how do you translate Jewish law into a legal framework or into architectural rules or design in a nation that is so motivated by money and financial gain?
I think you're asking two parts question. How would you do it if you could? And how the heck do you think you'd be allowed to do it, right? So at the moment, I'll start with the second. At the moment, people are kind of fed up with what has been called surveillance capitalism. And there really is a big push to create not just state privacy laws, but a national privacy law that can protect us wherever we are in the United States. And so I'm hopeful that with the right proposals, the political will be there. What are the right proposals? I think the number one takeaway is move away from the individual, the fake notion of the individual as both the one who decides what privacy means to them and whether they're going to pursue it or not, when they're going to protect it or not. Be realistic about the power imbalances and the information imbalances between the users and the takers. And let's decide as a society what set of obligations and actual limits and categorical rules we want to say you're allowed to use information this way or you're not allowed to use information this way. We can leave, obviously, spaces open for information to be used in productive ways, but the kind of unlimited life of the use of that information is something that already in Europe and in California and in Washington and in Illinois, we've started to push up against. But changing the focus and saying, let's make rules about, let's say that, this is the limit and you can't use information in this way after this point. Danny?